May it please the Court. I'm Emily Moore. I'm appearing on behalf of Dr. William McCoggle, who is joining us in the courtroom today, employed with the Florida Education Association, which is his Teachers Advocacy Association. And, Your Honors, I'd like to reserve about 2 minutes for rebuttal. I'm here this afternoon because the Division of Retirement has done a serious injustice, not just to Dr. McCoggle, but to the state of the Florida retirement law of forfeiture itself. And here on a de novo review, you have the authority to make this right. I'm going to show this court why the division is wrong as a matter of law and why it's wrong as a matter of policy. As a matter of law, you know already this is a de novo review. This court does not owe any deference to the division's erroneous decision. It is a pure question of law. And we didn't have very much in the way of a factual dispute, except for whether the crime to which Dr. McCoggle pled was a specified offense. And even if the division believes that it has no discretion or any statutory authority to do anything except forfeit his benefits, this court does. My client did not commit a specified offense within the meaning of the Florida forfeiture law, and the division has not proven that he has. If this court is going to follow its own precedent in Williams versus Christian, it must restore Dr. McCoggle's retirement benefits. As a matter of law, this court has already said that the authorities are too numerous to even mention with regard to how a forfeiture statute is construed. In Williams versus Christian, the court specifically cited Ireland versus Thomas and said that specifically that no citation of authority is required to support the rule that forfeitures are not favored in law. They are harsh exactions, odious, and to be avoided when possible. Statutes imposing forfeitures will be strictly construed in a manner such as to avoid the forfeiture, and will be liberally construed so as to avoid and relieve of the forfeiture. In strictly construing the forfeiture provision here today, Your Honors, I ask that you would not do what the 3rd District Court of Appeal did in Warshaw. That was a case which I believe was wrongly decided, and the dissent was clearly on point in that case because it resolved all doubts in favor of the retiree. And I ask you to resolve all doubts in this case in favor of Dr. McCoggle. As a matter of policy, the conduct in which my client engaged is not the type of conduct for which the legislature intended public employees to forfeit their benefits. His actions were totally unrelated to his job as a physical education teacher in the Miami-Dade County school systems. We had Andrew J. McMullen, who was the state retirement director for 21 years, to appear as a witness in these proceedings. He is currently retired and has been since 2000, the year 2000. I served as his chief legal counsel from 1998 to 2001. Mr. McMullen testified that he would not have entered a forfeiture under the facts of this case. He testified clearly about what the legislative history told him. He participated in it. He reviewed the facts, the grand jury report, and all the evidence that the division had before it. And he said this case did not warrant a forfeiture. And as he told me many times when I worked for him, the forfeiture law was designed to sanction the employee or the public official who would bite the hand that would feed him. Dr. McCoggle did not.
I appreciate your argument, and I also find Judge Cope's dissent very intriguing. We have a finding here in paragraph 18 of the recommended order that the theft was committed by your client's assisting teachers in getting paid public funds from the school board for which they were not entitled. And the grand jury report made similar findings.
Yes, Your Honor, the grand jury report made those findings, and those were alleged in the administrative hearing. However, there was no one that came forth at the hearing to attest to Dr. McCoggle having assisted them in receiving funds of any kind.
So you're saying there's no evidence to support the finding by the ALJ?
There's no testimony before this court that Dr. McCoggle assisted anyone. There's no evidence other than the grand jury's report, which was not corroborated by any testimony, that any of the teachers that were even employed actually took his courses, or they were the ones that engaged in the questionable conduct of not attending classes and getting transcripts or whatever credentials to which they were not entitled. This was a very political time with the grand jury investigating what they alleged to be teachers who cheat. And out of this alleged conspiracy, Dr. McCoggle is the only one who was charged, and the only one who has been charged to date. There is no evidence of any conspiracy. Nevertheless, he did, for many reasons, plea. He entered a plea of guilty to the crime of organized scheme to defraud. There was quite a lot of plea negotiations that went on. He was initially charged also, as your honors are aware, with grand theft as well. However, after engaging in these plea negotiations and being assured, first of all, which was his primary concern, that his wife would not be charged, then that he would not forfeit his retirement benefits, and that also he would not be sentenced until the others allegedly involved were charged, he agreed to enter that plea. It was not explained to him, and he did not understand until we were in hearing that the allegation that the victim was the Miami-Dade County school system was going to be held against him, because it was specifically because of the allegation that he stole from the district was his reason for not initially entering a plea.
If that is correct, and I certainly have no reason to doubt what you say, wouldn't the remedy, though, be for him to withdraw his plea in the criminal case? In other words, I don't know that that issue is something is a matter of concern to the Division of Retirement. All they know is he entered the plea. Now, what promises were made to him and what assurances were made to him is another matter. If he was misled, wouldn't his remedy be just to take his plea back, and that would undo the entire thing?
If it were possible, we would endeavor to do that. However, we don't have access to that remedy. Nevertheless, this court has the authority under Williams v. Christian to
Well, what do you mean you don't have access to that remedy? You can file a post-conviction motion in the criminal case and allege that your plea was entered involuntarily, that it was entered on. We see these cases on a daily basis.
Well, I did represent Mr. McCoggle.
Well, I understand that. I understand that.
There, but I am aware that there have been negotiations there, and that the state attorney's office has advised for a number of reasons that they would not allow that to happen. That's all I know with regard to the withdrawal of the plea, is that has been attempted and it would not prove successful. Additionally, that would also not address Dr. McCoggle's concern that were he to not enter a plea of some sort, he would be he's 75 years old. He's not in the best of health. He doesn't want his wife dragged through this. He entered this plea because he thought that the mitigating circumstances under which he entered it would relieve him of retirement forfeiture. And under the Williams case, it should do so even today. Because even in that case, as your honors are aware, the Commissioner Christian was allowed to enter a plea with the understanding that his benefits would not be forfeited if it was plea B rather as opposed to plea A in that case. Additionally, as in Williams versus Christian, Dr. McCoggle has not done anything in his official position, in his capacity as an educator, to take any money from Miami-Dade County. The administrative law judge also found in her findings of fact, and they are numbered 16 and 17, that the evidence clearly showed that the performance of his official duties was in no way related to what was alleged to have happened here. Specifically, Judge Hunter said, the evidence supports petitioner's claim that his plea of guilty to a scheme to defraud was not related to the performance of his official duties. In finding of fact number 17, she says the grand jury's final report that was introduced and petitioner's testimony support a conclusion that he charged the teachers fees, but he took no money directly from the school district. He charged the teachers fees whether they were even employed by Miami-Dade County Schools. He had students in his classes taking these certification courses who were from several districts, and some of them may have even been from out of state. The point, Your Honors, is that he was not conditioning his fee, the receipt of his fee from those teachers, on where they work, whether they work, for whom they work, or in fact whether they had a job at all. So to hold him responsible for what they did or didn't do with whatever credentials they had is beyond the purview of the Division of Retirement. The question here is whether he engaged in a theft, a specified offense, which are clearly outlined under the statute. And specified means specified. And I contend it does not mean whatever the division can fit into what is specified. The division argues that he is guilty of theft because organized fraud because it's a lesser included offense of theft. It is not a lesser included offense of theft from the employer. And it is theft from the employer that is the specified and forfeitable offense. Dr. McCoggle has not committed theft from his employer. Additionally, on accepting that plea, and I don't disagree much with the Judge Hunter's findings of fact, I did, however, attempt to make a point of clarification, which would have gotten me nowhere with the division, because, as I said in my brief, we have had our discussions over a course of years concerning this case. But the school board itself was not a party to these provisions, so that the position that they may or may not have taken is not in this record. My attempt to clarify that also got no place. And as I read Judge Hunter's initial recommended order, Your Honors, I read those facts, and when I got to the conclusion, I was stunned, because I actually thought the facts supported a different conclusion. The legislature intended for conduct such as Director McMullen told me when I worked for him, that conduct of an employee which would bite the hand that would feed it, would steal from their employer. If a public employee committed murder, so long as it was not of the head of the agency, it was not a forfeitable offense.
But the ALJ seems to be saying that because Mr. McCoggle pled guilty to a violation of the statute that relates to committing a specified offense, that answers that question.
And, Your Honor, I must disagree with Judge Hunter in that, because she failed to look at the reasons for Dr. McCoggle's plea. And under the Boone case, which is also pending before this case, another administrative law judge considered those mitigating factors of health and family stress and age and so forth that my client also presented. And I maintain under the Boone case, which that judge has ruled on, despite the divisions having entered a contrary final order, that this court on a de novo review is authorized to consider these mitigating factors and to consider that Dr. McCoggle did not understand that by virtue of having the victim in the charge to which he pled to be written out as Miami-Dade County Schools, that would then subject him to forfeiture, because he never took anything from his employer. He never did anything wrong in the conduct of his duties as an employee in Miami-Dade County. He worked for the district for 23 years without a spot or blemish on his record. And for the division to maintain and to hold that because he engaged in some questionable activity in a totally unrelated work and then erroneously entered a plea that he didn't understand subjects him to forfeiture is wrong. It's wrong as a matter of policy. It's wrong as a matter of law, Your Honors. And I maintain that you have the authority to right this wrong on this de novo review.
You're well into your rebuttal time. If you wanted to save some, we can give you an additional minute, but you're
I
pretty well over it.
will give way, Your Honor. Thank you.
Counsel. May it please the Court. Jeff Christian for the Florida Division of Retirement. Your Honors, the only issue raised on appeal as below is whether or not organized fraud constitutes a specified offense under the forfeiture statute, Section 112.3173. The Division's position has been all along that organized fraud is a type of criminal theft that compels forfeiture under the statute. The statute, the provision in question states that a specified offense includes the committing, aiding, or abetting of any theft by a public officer or employee from his or her employer. Any theft. There's no limitation on the type of theft that might apply. It does not refer to Section 812.014. The legislation could have limited it in such a fashion, but it chose not to do so. Furthermore, the statute does not define the term theft. Black's Law Dictionary defines theft as, at least in part, as a popular name for larceny, and then goes on to define larceny in part as obtaining property by fraud. Now,
Well, in that definition, the appellant here didn't obtain any county property by fraud, did he?
well, the term theft, well, he was charged with organized fraud, Your Honor, and the victim of this crime was Miami-Dade County Public Schools.
But going back to how you just defined theft and larceny, but it seems to me he's been charged with a scheme by which teachers defrauded the county.
The victim of the crime, Your Honor, in the division's opinion, was the county. It was the county who was paying the teachers salaries based on their certifications and recertifications, based on increased in wages, based on the certification, based on promotions. The teachers were in on the scam the whole way through, Your Honor.
I understand. So he was charged with abetting the theft by the teachers.
He was charged with, he was charged with grand theft originally and with organized fraud, scheme to defraud $50,000 or more. The victim of the crime was named in the information and in the amended information as Miami-Dade County Public.
But the grand theft charge was ultimately dismissed or something, was it? Or never?
Yes, the grand theft charge was ultimately dropped, and that's, in my opinion, because he couldn't be convicted of both. They would have to convict him of one or the other. It would have been a violation of double jeopardy for him to be convicted of both. I don't know if that was related to the plea agreement or not. That would be something for counsel to address.
Well, you know, there's nothing in the record on that point, I guess. The reason I ask the question is it's a little fact that's sort of consistent with what counsel says about her client's understanding of the plea. I mean, why would they have dismissed the grand theft charge if it were not to prevent this very thing from happening?
We don't have any evidence. The plea agreement does not address the reasons why it was entered. It was just simply that he agreed to three things. Number one, that he would plead guilty as charged in the amended information, that he would serve a 2-year prison sentence, and that he would pay restitution to the Miami-Dade County Public Schools in the amount not to exceed $100,000. He was adjudicated guilty. Under the forfeiture statute, where we have a public employee who's been convicted prior to retirement of a specified offense, we forfeit their benefits. The division's position is that this is a specified offense of theft based on the plain reading of the specific specified offense and based on the related case law, which conclude that the elements of the crime of theft are all included within the elements of organized fraud.
But both the grand jury report and paragraph 18 of the administrative law judge's recommended order describe the act, the crime, as theft by assisting teachers in getting paid public funds of the school system to which they were not entitled. That's how it seems to, that's the crime it seems to me we're dealing with. Do you disagree with that?
Well, I know what the grand jury stated, and I know what the judge stated in her recommended order. The division did adopt the recommended order in toto. However, he pled to a different crime, and the crime was organized fraud, which is a specified form of the underlying core offense of theft.
Well, only because of the way it was committed here, is that right? I mean,
well, the case law is fairly clear that organized fraud is simply a specified form of theft. It's the higher, theft is the core underlying offense, and then organized fraud is just a finer specification of theft. They're listed under different chapters under the statutes. However,
but this would still have to be theft from the public employer, right?
That's right, and there's no, and under the
In other words,
specified offense,
in other words,
there's
if
no
the upshot
requirement.
of this whole thing was that under a plan like this, someone got money from teachers that he was not entitled to get because he really wasn't giving the instruction or whatever, that would be taking the money from the teachers for not providing the instruction, which in turn would lead to certification or additional qualifications. That would be taking the money from the teachers, that wouldn't get it under this statute, would it?
No, Your Honor. Him simply stealing from the teachers, again, Your Honor, it's the division's position. I think it's rather clear that for all the years this was going on, there were no courses being taught, there were no tests, there were no classes, no teachers ever.
Which means he
were
got
taught
money
anything,
for these courses from teachers
who were also involved with
that he was
with
not
the
entitled
fraud.
to have. So you could make an argument from what you're just saying here that he took money that he wasn't entitled to from the teachers.
Right. The teachers are presently being pursued by the county, and they're being either terminated or suspended based on these cases. These are all in the Division of Administrative Hearings. Dr. McCoggle wasn't teaching any classes. The teachers would go, and they wouldn't learn anything. They just paid money. They would receive transcripts, and then they would receive their certifications and recertifications. They were in on it. The victim was the school board. They're the ones who were paying the money based on this vehicle, this fraudulent vehicle that Dr. McCoggle created. The teachers were in on it too. They're being punished by the school board by being either terminated or suspended. Now,
Counsel, going back to paragraph 18, the appellant argues that other than the plea, I think this is her argument, other than the plea in the grand jury report, there is no evidence in the record to support the fact that the appellant schemed with certain teachers and assisted them in being paid public funds wrongly. What is in the record with respect to that finding?
well, the division's burden, Your Honor, is to show that Dr. McCoggle was a public officer or employee, that he was convicted of a specified offense, and that specified offense occurred prior to retirement. The only issue below and here again was whether or not it was a specified offense. The rest of the elements under the statutory forfeiture provision have been satisfied, either by the fact that they weren't argued about below. So the only burden we had was to show that he committed a specified offense, and based on the other factors, he pled guilty to what we believe to be a specified offense, and therefore it's appropriate that his benefits be forfeited.
And again, that specified offense is which subsection under 112-3173 2E? Is it 2, the committing, aiding, or abetting of any theft by a public officer or employee from his or her employer?
That's correct, Judge.
Okay.
And again, Your Honor, the case law doesn't, and don't be fooled by that the word theft is used in the statute and we was convicted of organized fraud. The case law doesn't confine the determination of whether a crime is a specified offense to an examination of the title of the crime. okay? And now, as far as Dr. McCoggle argues about the relation to his public duties, look at the specified offense we're going under. Where does it say that there has to be a connection to his public employment? Where does it say that it has to be related to his job duties? No, it's not there. You can read it. I've read it and reread it. It's not there. That nexus is not required. He would like for you to believe that, but it's not there. There's no mention of a public employee's duties to his or her employer under theft. The plain language mandates forfeiture if he's convicted of any kind of theft from his or her public employer. It's unambiguous, Your Honors. And further, if you compare the specified offense of theft with some other specified offenses, such as bribery, misuse of public office, and the catch-all provision at the end, this is sections 112.31732E3, 4, and 6, you'll see that these specified offenses do require some connection to the employment or the public duties of the employee. Had the legislature intended to limit the application of the specified offense of theft in this manner, it could have done so. It could have written it right in there.
Counsel, the plea agreement says that the defendant pleads guilty to one count of an organized scheme to defraud in violation of Section 817.034, sub 4A1. The statute book says that offense is any person who engages in a scheme to defraud and obtains property thereby is guilty of organized fraud, punishable as follows, and $50,000 or more is subsection 1. So the question I've got is, was he pleading guilty to obtaining property from the teachers? I mean, that plea doesn't seem to me to be a plea of engaging in abetting or assisting the teachers in stealing from the school system.
Your Honor,
he didn't plead guilty to violating 112.3173.
That's right, Your Honor. What happens is that once we understand that someone's been convicted of a possible crime that could affect their retirement, then we conduct an investigation. However, if you look at Section 817.034, Your Honor, actually under subparagraph 3, it actually defines the meaning of the terms used in the definition of the offense. And you'll see that those includes obtaining can mean, beg your pardon, Your Honor, with intent to defraud or intent to obtain property which results in appropriating the property to the use of another person not entitled thereto. Okay, Your Honor? So for that, and that's precisely what happened here. He set up this scheme which resulted, yes, he got paid by the teachers, but the teachers received monies that they were not entitled to based on the scheme. They received raises, they received promotions, and things of that nature because of the certifications and recertifications that they were alleged to have earned through his classes. They didn't earn them. And so for that reason, if you compare the elements of organized fraud and theft, they do overlap, and as I mentioned before, all of the elements of theft are in organized fraud. Organized fraud has one additional element, and that is engaging in furthering a systematic ongoing course of conduct. So, Your Honor, I may be running out of time. I would briefly like to distinguish the Williams case that was mentioned earlier. Williams involved bribery in connection with the employment under Section 121. Here we're dealing with different crimes, different statute. Furthermore, the statute we're dealing with is based on a constitutional provision. Chapter 121 wasn't. Section 121 wasn't. Furthermore, this court in Williams carefully distinguished the crimes at issue in Williams, and I don't think that can be done in this case. The court pointed out that bribery applied only to the one who corruptly offers the bribe, whereas receipt of unlawful compensation reached only the acceptor of the bribe. And furthermore, again, you'll note that the Williams crimes both involved an element of official behavior. Here, that's not the case. Also, I'd like to briefly distinguish Boone. Dr. McCoggle's reliance on Boone is unfounded. Boone involved a no contest plea. This case involves a guilty plea. Further, as she mentioned earlier, the final order modified or rejected several of the ALJ's findings, and Boone is on appeal before this court. I don't think she can rely on it as precedent. In conclusion, Your Honors, I would ask that the final order be affirmed. Dr. McCoggle was convicted of a crime which constitutes a specified offense, and therefore he must forfeit his FRS pension. Thank you.
Very briefly, Your Honor, if I may. Thank you. Counsel, on behalf of the division, argues once again and misses or dismisses the fact that this is the offense specified under the statute is theft from the employer. It is not simply theft. We're not simply talking about a lesser included offense. Under the statute, as the testimony of retired Director McMullen has shown, it has to be job related. He administered it that way for 21 years. The legislators who talked with him and had conferences creating the section of the statute pursuant to Article 2, he testified that it had to be job related, and they were very specific about that. There's nothing in this crime that is alleged to have occurred that related to Dr. McCoggle's employment. Counsel has pointed out that the teachers, it's been alleged that the teachers got money from the district and they were not entitled to it. There is no testimony in the record that these teachers did not do their work and did not do it well. There are no performance deficiencies. They went to work, they were paid. Whether they had credentials or not was another issue for the district to address, but they did their work. Thank you.
You don't just keep going. That's up to you.